Namaste and welcome to a presentation on company meetings. In this presentation, we will have a look at company meetings in three components. What is the meaning of meetings? What are types of meetings? And what are the requisites of meeting? If we look into the meaning of meeting, meeting is a gathering or assembly of two or more persons in a particular place to discuss some lawful business of common interest. And whatever decisions they take in a meeting, it will be in the form of resolutions. And that will be based on the opinions expressed by the members at the meeting. Means the important thing to note here is two or more persons in a meeting, a specific place, a lawful business discussion of common interest, and ultimate result will be the resolution, which represents the decision taken after deliberations. From there, we move to what are the types of meetings in a company. Here we find three stakeholders: members, directors, and class. And all the three have their own sets of meetings. We will get into their details. Who are members? Members are subscribers to the memorandum of the company who have agreed to become a member of the company, and their name appears in the register of members. This is one type of member and as defined in the Act. So there is second set of members. Every other person than the subscriber to the memorandum who agrees in writing to become a member, say he signs an application for shares and whose name is entered in the register of members. He might not have signed the memorandum, but he has signed the share application or an agreement to buy shares from the company. Third, any person whose name appears in the register of members as a beneficial owner. Therefore, a beneficial owner, a person who have applied for shares and agreed to buy the shares, and a subscriber to memorandum, all three whose names appear in the register of members are members of the company. Who is a director? Director is one who is appointed to the board of the company. He is an individual and his main function is to direct, control and manage the affairs of the company as a body. And he performs his functions in accordance with the provisions of the Act. And directors are collectively known as board of directors. The third set of people is the class. There are class meetings which are held: shareholders meetings, directors meetings, and class meetings. Who are these? There may be a class of shareholders and their meeting may be pertaining to variation of their rights where they have got to be consulted because their privileges are being affected, or for conversion of one class of shares into another class of shares. And for this meeting, there should be a provision in the memorandum or articles. And whenever a class meeting for variation of rights is conducted, it is essential that the resolution in a class meeting has got a support of 3/4 majority of the members of that class. Just like this class of shareholders whose rights are being varied, there may be a class of creditors also. Now creditors are called to meet when there is a scheme of arrangement being worked. And a meeting of creditors might be called to have an arrangement in the course of winding up of a company. Once again, any resolution that is passed in the creditors meeting, it is passed by a majority of 3/4 in value of creditors, and the same is sanctioned by court, and then it becomes applicable to the community of creditors as such. Therefore, both class of shareholders for variation of rights and creditors in respect of the arrangement on winding up or liquidation, in both cases value is 3/4, and then the resolution becomes binding, subject to compliance with the court order or with the memorandum. And third set of class are debenture holders. And the meeting of debenture holders normally takes place in terms of the debenture deed, debenture trust deed. And the meetings are held, once again, whenever there is a need to make any variation in their terms in the course of reorganization, reconstruction, or amalgamation or winding up. And whenever the company goes for issuing further debentures or vary the rate of interest, then also the meeting of debenture holders becomes relevant. And all rules pertaining to the meeting of debenture holders, the rights of debenture holders, and the way they are to be protected are all contained in the trust deed, which is signed as a part of the document. We have seen a class of shareholders, creditors, debenture holders, and when the company is under liquidation, in the course of distribution of proceeds of winding up, there might be some sacrifices required by the creditors, and there should be a commitment from the part of contributories or shareholders. Now that also is coming under the class meetings. And these meetings might be held under instructions of a court. And as we have seen, creditor is a person to whom the company owes money. Contributory is a shareholder or a member who, by virtue of his holding, is required to contribute to the assets of the company when the company is being wound up. That way, meaning of the meeting: member, director, and class, and they have their meetings: creditors meeting, debenture holders meeting, creditors and contributors meetings, board meeting and committee meeting in respect of directors, annual general meeting and extraordinary general meeting in respect of members. We will be specifically going into the details of members, and directors meeting we will handle when we deal with the topic on directors. Class meetings, we have made a brief reference while discussing different classes of people, and that will suffice for the meeting of class. And that brings us to understanding meeting of shareholders. There are two types of meetings: annual general meeting and extraordinary general meeting. We will first take the meeting as indicated in section 96(1). It says every company has to hold in each year a general meeting which is called annual general meeting, and the notice of that meeting must indicate that this is an annual general meeting, and between the date of one annual general meeting and the next, the gap should not be more than 15 months. However, in respect of first annual general meeting, it is linked to the closure of the first financial year. The first financial year of the company may be 12 months or more than 12 months or less than 12 months. What the Act says is, once you close the financial year, the first annual general meeting must be held within 9 months of the closure. You close the financial year and hold within 9 months. And in case this is in respect of the first annual general meeting, in case of all other annual general meetings or in case of subsequent years, you should hold the meeting within 6 months of closing of the financial year. And once you hold the first annual general meeting, you will be holding it after financial year and 9 months. That will cover the year of incorporation. There is no requirement for an annual meeting for year of incorporation. This is just as a clarification. And in case of meeting other than first annual general meeting, where we said it should be held within 6 months, the registrar of companies on application can enhance these 6 months, and he can extend it by 3 months, means up to 9 months, but it is on a case-to-case basis. And there is a requirement. When you hold an annual general meeting, it should be held during business hours, and it should not be a national holiday. When you say business hours, it is 9 a.m. and 6 p.m. And national holiday is one which is declared as such by the central government. Where can you hold the meeting? You can hold at the registered office itself or within the city where your registered office is situated. When you say within the city, maybe in a hall or hotel or somewhere, you can hold it, but it should be within the city where your registered office is situated. This is in respect of a listed company. In case of an unlisted company, it can hold it in any place in India, provided members give their consent to it. And this is the basic requirement in respect of an annual general meeting as covered under 96 subsection 1, 96 subsection 2. Now there is one more set of meeting called extraordinary general meeting. We have seen annual general meeting, and anything which is not an annual general meeting, it is an extraordinary general meeting. Only two sets of meetings. and the board may call the meeting at a place within India. It is called by the board on its own. Board may. That is one option. An extraordinary general meeting is called by the board on its own at any place within India. But there are cases where members who hold 1/10 of paid up share capital of the company or 1/10 of total voting power, if they give a request to the company or the board shall convene an extraordinary general meeting. So to say, all meetings of the company are called by the board. Annual general meeting and extraordinary general meeting. But in case of extraordinary general meeting, board has got an option to call at its discretion anytime, but it is bound to call. It shall call if a request for calling a meeting is given by shareholders who are holding 1/10 of the paid up capital or 1/10 of voting power. Now, when people who hold 1/10 of share capital give a request, it is called requisition. What does it include? The requisition from the members. It will set out the matters to be discussed in the meeting, which subject they want to discuss. It should be signed by the requisitionists. And board has to take a decision to call the meeting. And the meeting has to be called within next 45 days. Deciding day is 21. Then after that you give another 21 days notice for the meeting. That way you require 45 days. If the board doesn't decide to call and the decision doesn't come within 21 days, section 100 gives a power to the requisitionists. They can go ahead and call the meeting themselves. Means they wait for 21 days. If within 21 days board doesn't call the meeting or decide to call the meeting, in next 3 months, the shareholders who have requisitioned can themselves go ahead and call a meeting. And that meeting has to be held within 3 months from that 21 days. And who will convene that? They will be in charge. Requisitionists will be in charge. And what the company will do? Company will be responsible to pay all reasonable expenses for holding such meetings. And will the company bear all the expenses? No. If the failure to call the meeting by the board was due to the default of directors, whatever reasonable expenses refunded to the requisitionists will be deducted from the remuneration under section 197, which is paid to directors. Therefore, two options of extraordinary general meeting: board may call, board shall call. When board shall call on requisition, if there is a failure to call within 21 days, the requisitionists themselves can call the meeting and they will get reimbursed for the expenses incurred. Amounts will be recovered from the directors. That is regarding extraordinary general meeting. Now, these two meetings, annual and extraordinary, were called by the board. Now, there are situations where the company law tribunal can call the annual general meeting. When will it call? Board is supposed to call under section 96. If it fails to call the meeting and there is an application to the tribunal by a member to call the annual general meeting. The tribunal may pass an order to call the annual general meeting. This is specifically regarding annual general meeting, and its special instructions may include that even one person who is present in that meeting can constitute a valid meeting. When you say one person, because for a meeting essential requirement is minimum 2 people, but here the tribunal as a special case can give such instructions that the company having been not able to call a meeting, it can give a direction that even one person present in person or by proxy can constitute a meeting. And whatever meeting held on the orders of tribunal will suffice as an annual general meeting validly held. This is the annual general meeting held at the orders of the tribunal. And tribunal has also got the powers to call meetings of members. Here we were talking of an annual general meeting. Tribunal can also give orders to call meetings which are extraordinary, which are not annual general meetings. It can be done on the application of any director or member. When the company is not able to call on its own, they can approach tribunal. Tribunal on their application will pass an order to hold the meeting, and tribunal can also do it suo motu, means on its own without any application. Tribunal can proceed to call the meeting, and it can give instructions as to how the meetings will be held. And once again, it can go to the extent of saying that even one person present in person or proxy can constitute a meeting. And any meeting, whether it is AGM held by the order of tribunal or held by the order of EGM held by the order of tribunal, it shall be recorded as held and conducted as a valid meeting for all purposes of the Act. That way, we have covered now meaning, types of meetings, and in respect of members, we have seen who will call annual general meeting, board will call it, extraordinary general meeting, and then how tribunal can step in and call a meeting of the members. Having seen the meaning of meeting, type of meeting, now we are moving to the next stage of requisites of meeting. Now, requisites of meetings are basically 4. The meeting has to be convened by proper authority through notice. Notice becomes a crucial item here. Then the meeting is constituted. It is convened and constituted once again as per notice. Therefore, we will cover convened and constituted and study notice in that regard. And we have 4 aspects to note here. Notice of meeting, statement annexed to notice, circulation of members' resolution, and resolutions requiring special notice. These 4 variants of notice we will be studying in detail. Then the meeting should have a requisite quorum. Notice with quorum makes the gathering as a properly constituted meeting. Then it should be conducted, convened, constituted, conducted by a duly elected chairman. We will study details about the chairman. Then while conducting, you will have certain concepts which should be understood. What is proxy? What types of votings are happening? Show of hands, poll, electronic voting, or postal ballot. Then what decisions are taken at the meeting? Now, this is the third requirement of a validly conducted meeting, conducted by these components. Once it is conducted, then it is documented. Documented in records, minutes are prepared, and filings are done. Therefore, requisites of a valid meeting is it should be convened, constituted, conducted, and documented with these various components. We will study each of these components in greater details for a better understanding. And notice is for both convened and constituted, because meeting has to be constituted in terms of the notice. What is this notice about? For a general meeting, a clear notice of 21 days has to be given by the company to the members. Can they give a shorter notice than 21 days? In case of an annual general meeting, they can give shorter notice, but 95% of the members entitled to vote have to give their consent in writing or electronic mode. And in case of any other general meeting, "95% of the voting power or 95% of the people who are entitled to vote have to give a consent. Only then the notice is valid. Otherwise, a minimum period of 21 days is required to be given. What will the notice indicate? Notice is just like an invitation to attend the meeting as a matter of right. It will specify the place, day and date and the hour of the meeting, and it will detail what is the business to be conducted there, where, when, what time, and what will you discuss. Who will receive notice? Every member will receive notice, the auditor will receive notice, and every director will receive notice. What happens if there is an omission in giving notice to any one of these? So long as it is accidental, it will not affect the validity of the meeting as such. Notice, contents, and its effect on the validity part of it. And any short notice to be consented by 95% of the capital holders. We have seen regarding the notice. Now, this is regarding the notice of the meeting. Along with the notice of the meeting, the Act requires you to annex something. They call it as explanatory statement. We have to look into that part of it. What is to be annexed to the notice? It is covered under section 102 subsection 1. It says, in respect of each item of special business. Now the question that comes is, we have to find out what is this special business. Because there are a lot of businesses to be dealt in the meeting. Each item is a business. 102.1 says, in respect of special business. Now, it has to do certain things. In respect of special business, the attachment has to say what is the interest of every director or manager in the business, every key managerial person and relative of him, to understand their interest. How does it affect the interests of the company and the rest of the shareholders? And the whole idea of this additional statement is to give additional information to members to state in this particular special business, directors and managers are interested, they have this stake and this is the benefit they are getting. To that extent, there is an implication on the company. Now that becomes very interesting because these details are to be given only in respect of special business. Means if in case of normal business, this statement is not to be given. It is defined that all business to be transacted is considered special in a general meeting except these four. If the business pertains to financial statements and reports of directors, if the business pertains to dividend, if the business pertains to appointment of directors or appointment of auditors. If the matter falls into any of these four, it is not special. This is general. If it is not any one of these four, it becomes a special business. And once it is a special business, the notice should have an additional detail as to what is the interest of directors and others, and that is to be annexed to the notice. Now this is in respect of annual general meeting. In annual general meeting, these four businesses are normally held. Therefore, if the annual general meeting holds something other than these four, details are required to be given. But in case of any other meeting, extraordinary general meeting, we have to note this annexure is a must because in an extraordinary general meeting, every business is special. Every business is special. Therefore, statement to be annexed to notice will cover all business of an extraordinary general meeting. And the annexure will look into if the special business affects any other company, then it will say in that other company what is the extent of shareholding of promoter, director and manager and the key managerial personnel, the same set of people, provided the stake is not less than 2%. If their stake is more than 2% in the related company, then we need to have more details about it. And if they say some documents pertain to this particular transaction, where those documents could be checked, where and when. And if a meeting doesn't disclose or doesn't annex these details, it is a default. Non-disclosure or insufficient disclosure renders these interested managers or directors or promoters responsible, and any benefit that they get will be benefit held in trust for the company and they are liable to compensate the company. Therefore, annexure to notice is mandatory. And any default here, every promoter, director, manager will be liable to penalty. Therefore, one simple thing, if the business is not the four businesses of the AGM, all other businesses and all businesses in an extraordinary general meeting, they are special. They need to have a statement annexed to notice on the interest of specified managerial personnel in the business affairs. We have seen the notice of meeting, statement annexed to meeting. There is one more thing. Members may ask for circulation of a resolution whenever the meetings are called. We will look into that. Circulation of members' resolution. Section 111(1), subsection 1. Whenever there is an extraordinary general meeting, members can give notice of any resolution which they want to move in the proposed meeting. When the members give that resolution to the company is supposed to circulate that statement to all the members who receive notice. But every resolution that a member gives has to be circulated subject to fulfilling some conditions. A copy of the requisition containing that statement has to be deposited at the registered office duly signed. And if it is a resolution to be moved at the meeting, it should be received by the company at least 6 weeks before the meeting. If it is just a statement, it should be received 2 weeks before the meeting. And when the shareholders want a particular statement to be sent to all members on a resolution or a statement, they have to deposit money with the company to meet the requisite expenses of dispatch of these statements. This is when a notice is being sent. After that, if the shareholders want certain details to be sent to every member on a resolution or statement. And as we have said, in case of a meeting, it has to be deposited 6 weeks before the meeting. And just because a shareholder has given a statement or a circular or a resolution copy to be circulated and he has deposited money, company is not bound to circulate. If the aggrieved person approaches the central government who declares that these statements are for undue publicity or defamatory in nature, but that has to be approved by the central government. Otherwise, whatever is deposited with the company has to be circulated to the members as a resolution or as a statement. We have seen notice of meeting, statement annexed to notice, members resolution, and there are certain resolutions which require special notice. Now we will also see that as an part of this. This is contained in section 115. What it says is, in respect of two businesses, one, if the notice contains a business which says that the retiring auditor shall not be reappointed, and another resolution which might state a removing director before his tenure ends. In respect of removal of a director and non-reappointment of a retiring director, the moment the members come to know of these two resolutions, they can ask the company to send a special notice to members, provided the members who request hold not less than 1% of the total voting power or not less than rupees 5 lakhs has been paid up. And such resolution shall be notified to all members ahead of the meeting. Now the special notice, there is rule number 23 which takes care of resolutions requiring special notice. It says the notice sent by members should be at least 14 days before the date of the meeting, and the company will give notice to its members at least 7 days before the meeting. Company has to receive minimum 14 days before the meeting, and it will give notice at least 7 days before the meeting. And where it is not possible to publish or send, they can publish a paper notification in an English newspaper and also in a vernacular which is circulating in the state where the registered office is situated. And this fact of the special notice will also be put on the website of the company. And the notice has to be published at least 7 days before the meeting. And this is pertaining to a retiring auditor and a removing director. This is regarding resolutions requiring special notice. That will be followed. To be called constituted, meeting has to be convened, and it has to be in terms of the notice, and there should be quorum. Only then it is constituted. What is quorum? Quorum is the minimum number of people who should be there in a meeting. In a public company, if the number of members on the date of meeting is 1000, the quorum is 5% personally present. Quorum is members personally present. If it is more than 1000 but up to 5000 number of members, 15 members have to be personally present. If the number of members of the company is more than 5000, quorum required is 30 members. Means at the commencement of the meeting, 5 people should be personally present in the first case, 15 people in the second case. If the number of members is more than 5000, 30 members should be present in the third case. This is in respect of a public company. Quorum in respect of a public company. In case of a private company, just 2 members personally present shall form the quorum. This is the quorum rule as indicated in section 103, subsection 1. What happens if the quorum is not present within half an hour? The meeting will be adjourned to the next week, same time and place. Or it may be adjourned to some other date, some other time and place as the board may decide. Okay, this is if the meeting is convened by the directors. What if the meeting was convened by requisitionists and there was no quorum? Then the meeting will stand cancelled. If it is requisitionists, they themselves are not able to get the quorum, the meeting is cancelled. And in case of adjourned meeting, which is adjourned to a next date, time and place, the company shall give a notice of not less than 3 days to members, either individually or by publishing in a newspaper. And what happens in the adjourned meeting? In the adjourned meeting, there is a privilege to the company. In the adjourned meeting, quorum or no quorum, whoever is present will be considered as quorum compliance. Therefore, adjourned meetings are meetings which are free from the rule of quorum. If the quorum is present, fine. If the quorum is not present also, the meeting is a valid meeting. It need not have to be adjourned once again. In this part A video, we have covered meaning of meetings, types of meetings, and convened and constituted part of the requisites of meeting. Please watch part B video for conducted and documented part of requisites of meeting. Thank you so much. Thanks a lot.